engage in.
Well,
what do you do about that?
One case is in the court here and was talked about here. I left that firm in 1986 and was on solo practice for 7 or 8 years. In Liberty County, the judge can't avoid having lawyers that are his friends appear in his court. There are 8 lawyers in town. He knows all of them. He goes to church with all of them. He knows their wives hang out together. So that doesn't really work. I have to appoint people I know. You don't want me to appoint people I have no idea whether they're competent. So I don't appoint people. In fact, in that case, I didn't appoint the firm, my former firm, to anything. But I have appointed lawyers from that firm to positions.
Well, that ties into something else we hear is that, amongst people that deal in probate matters, it is a rather incestuous group. I mean, it's small. People know one another. It is what it is. What are some of the ideas or options for enlarging that in such a way that you're dealing with qualified people to hear these issues, whether we're talking about recusals or other matters, to assure that as the obligation is passed around to someone else to handle matters, that it goes to a larger circle and that we don't have this problem of running from friend to friend.
I have nobody on my appointments list as a friend. I don't socialize with any of them. Maybe that's not true. 2 or 3 of them I may have known before I was on the bench, but I don't pick friends. I'm harder on friends. Most judges are harder on friends than enemies. But anybody that wants to come in and ask for appointments, I'll talk to them. And if they look like they're good, I'm always looking for new people because it's hard to find somebody that's competent to handle a bad, contested replacement administrator where the successor's got to come in and sue the original administrator and get money back.
What exists right now, either in statute or in rule, that would prevent the kind of conflict of interest that Judge Wendell, I believe it was, up in Denton County, was recently reprimanded for? That was a case I'm sure you're familiar with. Where
vaguely, I saw the article in the paper about it.
Where we directed fees, what were reported as substantial fees, to a firm that was formed and organized and owned by a woman who became his ex-wife. I don't know what the time.
I didn't really understand all that either. Obviously, that's improper.
But what's other than maybe perhaps your feeling of good sense and propriety, which I'd like to think we all have, what is out there in law that assures us that there is a remedy for that? Because some would argue, I'd argue, that the public, if he was guilty of what was widely reported, the public reprimand that he received, and you did mention that going through the Commission on Judicial Conduct is one way to deal with these things, certainly didn't seem like much of a reprimand to me.
Well, a public reprimand against a judge is a very serious thing. It's very difficult to get elected again after that sort of thing. That, I think, is the best thing. I don't know the facts of that particular case, but if a judge does something like that, the Judicial Code of Conduct says you cannot benefit personally from being a judge at all, or your family, period. I don't let and Christmas presents are brought up by lawyers, all kinds of Christmas presents. We send them away. We can't accept gifts, period. I can't go to lunch with somebody and have them buy my lunch. That's violates the canons of ethics. But how do you enforce ethics? Only the Conduct Commissions. You can't really write a book, maybe the Bible, that has a set of rules to go by that are very specific. Don't go into business with somebody that you appoint and give hundreds of thousands of dollars to. Because then there are going to be all these details you have to try to flesh out about what you can't do.
But wouldn't one way to help eliminate or reduce the likelihood of these kinds of problems be to establish some sort of threshold, perhaps a $5,000 threshold for approval by some outside body or review committee is entirely too low. Perhaps $10,000 is entirely too low. But when we get into numbers that are in the high 5 figures and 6 figures, referrals to the same individual or same firm, shouldn't those kinds of things come under greater scrutiny than is currently the process?
My decision to approve a fee of $500,000, if it's objected to, will be appealed to a 9-member Court of Appeals.
Who pays for the legal cost for that appeal?
Who's calling?
Okay, meaning out of the estate?
No, it depends. Or the party that doesn't think the fee should be paid has to pay for the appeal. And if the appellate court says it's okay, they should be paid, then you can go to the Supreme Court. There's 9 more judges that will look at the issue and decide whether or not it's appropriate.
But at what cost? I mean, you're an expert on what it costs to work through the legal system. So if somebody has that kind of broad authority on the front end, and they make a bad judgment or otherwise, they make the wrong decision, or they spend the money inappropriately, and they don't possess the ethics they ought to possess, I mean, what price does the individual pay? Assuming they have the resources to even tap to move it forward through the appellate process, I mean, is that really a fair remedy?
Well, it is, because if they win, they can recover attorney's fees.
Not automatically, correct?
Not automatically.
Right.
But if the court says that what they did was right, then the appellate fees can be paid. They're going to win. If they win, then the fee is going to be set aside, so they're going to get a financial benefit out of that. We have an adversarial system of justice, and it works very well, but it does cost money. And one thing I want to say about probate, money is used as a weapon in probate court. Probate court is family court after death. Family court is very bitter, personal fights between husbands and wives. But probate court is after death, where you can't really resolve the personal conflicts in a mediation because one of the people is gone or incapacitated. But there's still the bitterness and fighting is going on in family court. And even though they lost to the jury and the trial court ruled against them, and all the appellate courts ruled against them, they still think they're right, and everybody else is wrong. And there's not a system of justice that can avoid that problem, unfortunately.
No, but I sure think a threshold on the front end that might place some reason in the process and assure that abuses are caught early. That's going to be the only
Who would that be? Who would pay for that?
Well, and I don't yet know the mechanics to know.
We don't really have. I don't think we have that big a problem. I mean, I know right now I don't look good saying that because 2 people have been talking to you for 2 hours about how bad I am, but. We don't have that serious a problem. I mean, I approved lots of fees. 99% of them were totally unopposed. Everybody's in agreement with the work that's being done by the lawyers, and nobody's upset. But when you get somebody who has a lot of money, and part of my job is to keep somebody from using the ward's money as a weapon. One child gets to be guardian, and then the other children are saying, wait a minute, he's not taking care of mom, and he's using the mom's money to fight against him. Not a contested guardianship, he's just abusing the ward, and he's got all the control of the money.
And Mr. Chairman, I know we're running out of time, but I have one final question. But if it really, in the end, is not your money, somebody else's money, and your job is to administer the proceedings and to attempt to apply the law and justice fairly, why really do you care whether or not there's someone looking over your shoulder above a certain threshold as to how this money is released? Why would you care?
I don't care, frankly. I don't care. If the legislature wants to have an army looking over my shoulder, that's fine. But as a conservative, which I sort of am, I wonder who's going to pay for the army, who's going to feed the army. Because in a case that's gone on for 11 years, and now it's finally going up on appeal, and somebody says, well, you never should have done all that, and we want somebody else to look at it, other than the appellate court, who's already going to have to look at it all. We're going to have an office of court ombudsman, and that office is going to have people in that office, and they're going to have to be paid to do what I have already done with my staff's assistants, and to do what the appellate court's going to be doing already. I just don't know why it really helps. I mean, I understand that it would, maybe we'd sleep better at night if we thought somebody was watching out for us. I think I know I'm looking at it from my viewpoint, but I'm the guy with the finger in the back taking care of it. But I am not afraid of the legislature having anybody else they want, but I don't think it's practical to do that.
Thank you.
Judge, I here sent one.
Yes, sir.
Judge, and the question I had for you has already been asked by the chairman. I saw him on TV ask it. But you can't testify on anything, on an ongoing case in your court. But let me ask you this. Okay, let's just take your case.
Right.
Case A. And with the kind of testimony that we heard this morning, do you have any recommendations on how to just, I mean, you know, when you hear testimony like that in whoever's court and whoever the judge is, and, you know, when you hear testimony like that, it automatically raises a red flag with people out in the community. And do you have any recommendations that, and I wouldn't want anybody testifying like that gentleman just did and his son against anybody, you know, unless
I didn't hear what they said because I couldn't listen to what they said.
Well, I'm not answering it's an ongoing case, but what I'm saying
pretty well know
is that you know, for me not to take the wrong impression that whether it be a judge, probate judge from Harris County or Dallas County or Barrett County, that you know, it would seem to me as a non-lawyer that, you know, something's wrong, and just on first impression.
All I can say, Senator, is that's why I get paid such a huge salary, is to take the heat from people that are angry. Every contested case has a winner and a loser. And the loser never wants to say it's because I was wrong. He always wants to say, or his lawyer, and bad lawyers do this, the judge is crooked. The judge is corrupt. The judge is in bed with the other side. That's why we lost. We had a good case. It's just the judge's fault. I can't respond to that at all. I can't say a word about that as a judge. No judge can. I have to just be comfortable that I am doing the proper thing myself. And if I don't, the appellate court will reverse me, and that's fine with me. I do my job, and they have a different job. They have more time to look at it, and they have more people to help them look at it. But I really don't read the paper by myself. I don't listen except in open court, so that when they're saying one thing, the other side can say, well, that's not true, that's not true. So I'm hearing both sides of the argument as it's going forward. But I can't keep them. They have a right to say whatever they want to. I can't keep them.
No, I understand it. And then you just got to saying you get paid the big bucks.
Yeah, really.
It's like the chairman and I do. I get paid the big bucks.
He actually does get a little bit more money than we do.
But
mine is a full-time job, Senator. No,
I understand. Well, you know, I guess what I'm saying is that really ultimately these people that are listening to this, whoever they are, you know, for example, my constituents, I mean, I'm going to take the hit because they're going to say, well, they're working under your system, under the legislature. And ultimately, the chairman and I are going to have to take responsibility.
The system has to withstand review, and it has to be open. And maybe the lawyers on the other side of that case will write a book and explain what all went on so that there's an answer. And that's the problem with the free press, you know. And it's even worse with the internet because people can get on and say anything they want without even having to convince the reporter it's a good idea. But we have a free society, and they have a right to their opinions. And I have a job to do. I have to reach the best legal conclusion I can in every case. And I may be right, I may be wrong. I am not dishonest. I'm not going to do something. I mean, I know that you're not saying I am, but every judge that has a rich person who loses that can get to the public by whatever means, writing a book or getting the newspaper, is going to get blasted. He's on the other side. He's ruling for his former law partners because he's a friend of theirs or whatever. And we can't say, no, that's not true. We can't say a thing because we can't talk about it in public. So.
But, Judge, and I understand. I'm just saying that whether this person be rich or poor, free press or not, whatever, and, you know, they have a say.
Oh, absolutely. And I say they're going to have their say whatever change you make in the law, whatever increased scrutiny you have in the probate code.
I mean, but ultimately,
somebody's going to lose, and they're going to say the judge is a crook.
Well, the way I see it, and the way that rich or poor is that ultimately that's going to, the responsibility comes here, and that's what I wanted to. The point that I wanted to make.
It's a matter of selling to the public that we really do have the best system, and as far as I'm concerned, the best system in the United States for the ease of going forward and taking care of your own business. It's very good, Judge.
Okay, now, Judge, I'm going to give you one last chance at this because I've asked you several times. The whole purpose of this meeting today is for people to come up here with recommendations for improvements to the system. And as I've heard your testimony, you think we've got the best probate code in America. And as best I understand,